members of the public who have had a keen interest from day one, participating in the YouTube parliamentary streaming, as well as 408. We welcome you. As you follow us, we also follow the comments you're making about the process. You're welcome. Thank you very much. I'm now going to again indicate the timelines for the day. That immediately after I would have spoken, I'm going to allow Advocate Bauer and Ms. Fatima Ibrahim to introduce the witness, and we'll resume with the leading of evidence by Advocate Bauer and Advocate Mayosi. That will start immediately after this up until 12. And from 12, we will proceed to cross-examination by the legal team of the public protector up until 3. And thereafter, members will interact with the witness. Thank you very much. Advocate Bauer. Good. Advocate Bauer. Okay, just before Honorable Mahlaule and Honorable Nkosi.
Thank you very much, Chair, and greetings to everyone. I just want to raise one issue. It may not look important, but it's an issue that it shouldn't be a punishment to be physical and not virtually. It's very cold here. Very, very cold, Chair, please. Thank you.
Thank you, Honorable Mahlaule. And you don't seem to be alone. There are people who have just become happy after you raised that. So you're a good job, Stuart. Can you attend to that? Same thing we asked yesterday, that we will tell them when we need fresh air. So just tell them to switch it off. Thank you. Honorable Nkosi.
No, Chair, thank you very much. Chair, I just want to make 2 requests with regards to yesterday's witness, Mr. Mahlangu. Mr. Mahlangu indicates that in his tenure, he achieved clean audits in the PPSA. My calculation is that he was there for less than 2 years. He joined at the conclusion of one financial year, I think it was 17-18. And he would have been responsible for his own budget, which would have started in June. That would have been 18-19. No, he was implementing 18-19. He would have started his budget for 19-20 in June or September, around that. So he definitely is not responsible for 17-18. So I need records. I'm requesting records for myself, just to clarify myself, for which particular year he achieved a clean audit. Secondly, I would like to have a record of I'm requesting the Secretariat to provide us with a record of the hearing in his previous employment, so that I'm able to just trace how the DC arrived at the decision to find him guilty. So those are my 2 requests, Chair.
Thank you, even though long, but it's just 2 requests. I think we've noted those requests about the annual report in relation to issues of clean audit and a hearing records of the previous employment. Is that what you? From Land Affairs. Okay, that's fine. The requests are noted, and we'll follow that.
Chairperson.
I saw I'm not seeing your hand. Do you want to speak, Advocate?
Oh, yes. Yes, I'm sorry, Chairperson. I should have raised my hand. No, yeah, and good morning, Chairperson and honorable members. Just on those issues very quickly, just wanted to advise the honorable member that the financial year of the public protector does not start in June, it starts in April, but also to check what is the relevance of some hearing at Land Affairs here. But that's for you. The second question will be on your shoulders, Chair, but just the first one is just for information.
Thank you. Thank you, Advocate Mpofu. I normally, I get your point. This would not be the first request. Members would have before requested different forms of information. And when they do that, I stand back as a chair from questioning their relevance. I provide. But if it has to come to the inquiry, that's when I switch on the relevance. But giving them information, I don't get into that space. But I'm watching in terms of when we in the inquiry, whether any of those issues are going to be relevant to the motion. So rest assured, we attend to those issues. Thank you. Advocate Bawa?
Chair, Advocate Mayosi is going to be dealing with this morning's witness.
That's fine. Thank you. Ms. Fatima Ibrahim?
Thank you very much and good morning, Chair and members. Chair, I just wanted to mention that the annual reports are available in bundle F that the members have. It's number 1 to 6 of that bundle, if any of the members would want to go and read those annual reports. Is the witness on the platform? If you could please switch on your camera.
Chair, the name of the next witness is Mr. Futana Simon Tebele.
Futana Simon Tebele is our witness today. Mr. Tebele, can we hear your voice? Are you there?
Morning, honorable members. I'm here.
Okay. Thank you, Chair.
Thank you.
Mr. Tebele, can I please ask that you state your full name for the record?
Thank you, honorable member. Through you, Chair. My name is Futana Simon Tebele.
Mr. Tebele, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mqwebane. Please be informed that by law, you're required to answer fully and satisfactorily all questions lawfully put to you or to produce any documents that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that the evidence you give under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or a period of imprisonment not exceeding 2 years. Mr. Tebele, I'm now going to ask you to please take an oath or to affirm that the evidence you're about to give is truthful. Which do you prefer, the oath or affirmation?
I will take an oath.
May I please ask that you raise your right hand and repeat after me? I swear that the evidence I shall give.
I swear that the evidence I shall give
Shall be the truth, the whole truth, and nothing but the truth.
shall be the truth and the whole truth, but nothing but the truth.
So help me God.
So help me God.
Thank you, sir. Chair, the witness is now duly sworn in.
Thank you, Ms. Ibrahim, and thank you to you, Mr. Debele, and welcome to the inquiry. The inquiry is now in session. Advocate Mayosi.
Thank you, Chair. Good morning, Mr. Debele.
Good morning, Advocate Mayosi.
And good morning, honorable members. Mr. Debele, you made a statement for these proceedings, correct?
Yes, Advocate Mayosi and honorable members.
I'm going to take you through the statement that you made. We won't deal with the statement line by line or paragraph by paragraph, but we'll just deal with some of the salient features of that statement. Okay.
Thank you.
Can I ask you to put it up? It's in bundle D and it's item 9. So paragraph 1 and just keep going down. So Mr. Debele, you're currently employed at the PPSA as Senior Manager, CEO Support in the Office of the Chief Executive Officer, correct?
Correct.
Can you explain to the committee what your job entails and who you report to?
Thank you, Advocate Majosi, honorable members. I currently report to the Chief Executive Officer in the Office of the Public Protector, that is Ms. Tandis Banyoni. And my role in the office is to assist the CEO in the management of the institution, the CEO as the accounting officer. I conduct quality assurance of documents that gets into the CEO's office. And those documents, ultimately, most of them will go to the private office, which is the Office of the Public Protector. I assist the Office of the CEO in monitoring the performance of the institution in as far as the annual performance plan is concerned. And I act as the secretariat of the meetings that are organized by the Office of the CEO, which is the EXCO and MANCO. And I ensure that the resolutions taken in those meetings are followed up and they are implemented. And I also facilitate the organization of those meetings within the office. I manage the budget in the Office of the CEO together with its expenditure assisted by my finance. That is in brief the role of my position in the CEO's office.
You're a lawyer by professional qualification, right?
Yes.
You say in your statement you've never practiced as an attorney, but that you were a prosecutor for a brief period in the early days, correct?
Correct.
Can you tell the committee a little bit more about your work experience before you joined the PPSA?
Thanks, Advocate Majosi, through your chair and members. I started my career, as I indicated, that was for a short brief as a prosecutor. And after that, I joined Department of Finance in a division that was called then Inland Revenue. Inland Revenue is what is now called SARS. That was before it became SARS. So I was dealing with special cases on the income tax court roll. We were preparing cases for the receiver of revenue that were going to sit. And we were also dealing with administration of estates, because during that time, the South African Revenue Services now had a stake in terms of administration of estates. So we would calculate what was owed and submit it to the executor of the estate. And when the organization was formed in 1996, I was requested by the then minister, Minister Alec Ewen, if I remember well, to remain in the Department of Finance, and a unit was established called Tax Policy Unit. And that is where I was. And within National Treasury, because I joined before National Treasury was formed in 1999, then within National Treasury, I performed functions of tax policy, doing a research and advisory on policy, participating in the budget and the tax proposals. Then I was seconded to a unit called Public-Private Partnership Unit when it started around 2004. My role there was to check how public-private partnership transactions will be taxed. And from there, then I was assisting National Treasury in entity oversight, where most of the entities that were established needed treasury. So I served in the advisory committee of those entity oversights. Then I was in treasury for a period of about 15 years. Then I moved to Limpopo Treasury. That is where I was based, I think around 2007 as a chief director. Then I went to the Department of Transport when the province was put under administration to assist with the administration in that department. And that is where I left to join the Public Protector in 2017. Thank you, honorable members.
So you joined the Office of the Public Protector in June 2017, correct?
Correct.
And the position you occupied then was Senior Manager, Executive Support in the private office. Is that right?
Correct.
And you reported to the Chief of Staff, who was also in the private office. Is that right?
Correct.
So can you explain for us, Mr. Tebele, when you say private office, what do you mean? Who does the private office consist of?
Thank you, Advocate Majosi, through you, Chairperson. The private office within the Public Protector South Africa refers to the office where the executive authority sits. That is the Public Protector and the Deputy Public Protector. And it refers to the staff that is responsible to support that office. So we have an office of private office, which is almost distinct from the office of the accounting officer. All the staff supporting the Public Protector and the Deputy Public Protector, they are part of private office. I found the name there, then I got to know it as such. Thank you.
So you said the DPP forms part of the private office?
Yes, the executive authority, because in terms of our understanding, both the public protector and the deputy public protector, they are the executive authority. So they both form part of the private office.
So what support did you give the DPP, one? And secondly, what role did the DPP play in the organization?
In terms of the structure that I found there, I mostly worked with the public protector. The deputy public protector had support staff in terms of the investigations that were assigned to him. Because in terms of my understanding of how the office worked, the public protector would delegate certain responsibilities to the deputy public protector. And the deputy public protector with the staff that was assisting him, which was mainly in investigation, then they will deal with that. My role was as an entry point into both offices. When submissions are made to both the public protector and the deputy public protector, coming from the investigation team, we will be the first to receive such information. And after we have dealt with the information, then if it belongs to the deputy public protector, we will send it through to the deputy public protector. And if it belongs to the public protector, we will reroute it that way. So the responsibilities of the deputy public protector were mostly assigned through the public protector with the delegations.
So you say in your statement, in October 2018, you were requested to act in the position of Executive Manager, Corporate Services, right?
Correct.
And as Executive Manager, Corporate Services, you managed various divisions, including legal services, HR, ICT, and security management, correct?
Correct.
Now, Mr. Baldwin Neshunzi was the senior manager responsible for security from April 2017 until July 2019. Is that right?
Correct, although I may not get the dates correct.
According to him, and he will testify of this to this committee, he was moved from the position of senior manager responsible for security with effect from 1 August 2019, and he was moved into the position of senior manager in another branch, service management. Do you recall that?
Yes, I recall that.
So he says that he will say when he testifies that he didn't apply for this position and he did not at that stage have any experience in the matters that the customer service management branch dealt with. Can you explain to the committee why Mr. Neshunzi was moved from security to customer services?
Thanks, through you, Chair. What I will say is what I know, not that I actively participated in it. When Mr. Neshunzi came back from, I will call it from the suspension, there was a report which I did not have preview to. And apparently in that report, there was a recommendation that he be moved. I haven't seen the report, but I was approached by the former CEO, Mr. Mahlangu. He said to me, because of the role that Mr. Neshunzi is playing in security, And the current cloud that is there in terms of leaking of information, he deemed it best that he be moved out of that portfolio so that somebody maybe can come and manage that portfolio, because he's saying the information security that he is responsible for, he could not handle it the way that it needed to be handled. And there were areas in which they needed to check which place, which area was he best suited to. And I remember when he came back, I also indicated to him that the leadership is of the view that you be moved from the office of the security to another area. And at that time, there was an opening in the unit called CSM, and Mr. Neshunze was moved to CSM to be responsible, I think, for intake and assessment. That is how far I understand the situation of Mr. Neshunze. Indeed, yes, he did not apply. For operational reasons, he was moved to that area. That is what I got, and that is how Mr. Mahlangu, our former CEO, consulted me on, because he requested me to consult Mr. Neshunze with that offer, which I did.
So the report that you're referring to, and which you say you were not privy to, is that the Diallo Mokhashwa report?
Yes, there was an investigation in terms of the leaking of information within the institution. And that company was responsible to do the investigation. The reason why I'm saying I was not privy to the report is because during their investigation, they took certain laptops which they needed to check for whatever information they needed to check. And my laptop was also amongst those that were taken. So I requested that I don't participate in the work that they do, due to the fact that I could have been also the one that is being investigated, because my laptop was also taken. Thank you.
Now, Mr. Tibele, when the evidence leaders first met with you, we explained to you that we were tasked with leading evidence in this inquiry as a result of a motion in which allegations are made against the PP. And we also explained to you that those allegations of incompetence and misconduct arise from the SARB report and the Freda matter. Do you recall our discussion in that first meeting?
Yes, I recall the discussion.
Yeah. We then also told you that the motion also included an allegation about the PP having intimidated, harassed, and victimized staff, or having failed to protect staff when they were victimized, harassed, and intimidated by Mr. Vuse Mahlangu. Do you remember that?
Yes, I remember.
Yeah. So, and then we asked you to share whatever information you had in relation to those aspects, whatever direct knowledge you had in relation to those aspects. Now, let's start first with the CIX report, because I think it's easier to dispense with in your case. Given that you started at the PPSA on the 1st of June 2017, and that the final CIX report was issued later that same month, were you involved at all in this investigation and report?
Thank you, Advocate and the honorable members. When I joined the institution, the investigation, I would think that it was at the end, because my first interaction with knowing about the CX was in a meeting, because as I was out of the private office, I was in a meeting where the investigators were briefing the PP in terms of the report. My role in the report, because I was not there when the investigation was done, was mainly to deal with the editorial part of the report leading towards the report being issued. But I've never dealt with really the investigation of that report, except the editorial aspect of the report.
Thank you. Now turning to your affidavit, and I'll deal with the themes that you discuss in your affidavit, starting with the description of task team, which you do from paragraphs 6 to 8. You describe a structure called the task team, which used to hold meetings every Friday and chaired by the PP initially. And you say that the main purpose of that structure was to check on progress in producing reports and issuing notices. So my question to you, just for our benefit, was the substance of investigations also discussed at task team meetings, or was it limited just to monitoring timelines and the progress of meeting those timelines?
Thank you, Advocate and honorable members. When I joined the private office, the first meeting, besides the introductory meeting which I had with the public protector and the chief of staff, the first meeting was with a team called Quality Assurance, which was based in private office, which was assisting the public protector in the reports. So Quality Assurance, they were part of what we called a task team. A task team was a committee that was sitting every Friday, and the committee was chaired by the public protector. And what was appearing on the task team agenda was mainly reports or investigations that have reached Section 7(9) stage, or investigations that have already reached report writing stage. Those type of investigations, they will come and serve in the task team for the quality assurance team to go through them and to advise the public protector. And during those meetings, the quality assurance team would also deal with the content of the Section 7(9)s and the content of the reports during those meetings. And they will engage the investigators respectively through the leadership of the public protector who was chairing those meetings. Yes, contents during those meetings would also be dealt with, because the quality assurance team would go into each and every paragraph, read the whole Section 7(9) or the report, and give their views and their inputs. And if the report needed to go back for correction, it will go back for correction. Thanks, Chair.
So you say you were involved in this quality assurance process for task team. My question is, before performing the QA function for task team, what was your previous experience in quality assurance?
In my career, I've dealt with a lot of documentation in terms of quality assurance. To be specific, in National Treasury, I was also the co-author of that Chapter 4, which used to be called Chapter 4 of the Budget Review, where we were doing tax proposals. Most of the team members within the tax policy unit had their own way of drafting into that. And I used to serve in National Treasury in terms of quality assuring those budget documents before they were submitted. And even previously in my working career, I have been going through different documentation in terms of quality assurance. The assurance in the public protector, it was a different one in the sense that they had a specific template that they were following in terms of how they were doing and writing their report writing. So that is why my initial involvement was mostly on the editorial part and not much to do with the content. And to the extent that I will find something amiss in the content, then I will also engage the investigators in terms of the content. But I had done a lot of quality assurance documentation in my career, in my previous lives. Thanks.
All right. We've already covered your previous positions that you occupied in the office. Move on. If we can go to the next section of your affidavit, yes, that deals with the Miss Mulelekwa and Advocate Matlawe in issue. You described tensions that arose in the private office between Advocate Matlawe and Ms. Mulelekwa, who was then the acting chief of staff in paragraph 11. This is when you also were still in the private office, right?
Correct.
Now, can you very briefly, just for the benefit of the committee, tell us in greater detail what the cause of the tension between them was?
Thanks, Advocate and the honorable members. This will be my observation as I was part of the team. The quality assurance team, which was based in the Public Protector's Office, by virtue of the chief of staff being the most senior person in that office, they were reporting through the chief of staff to the public protector. The public protector had a direct link with the quality assurance team, but in terms of managing their documents and information that is flowing, they were submitted through the office of the chief of staff and myself. And in doing our work, we will look at the documents, and where we have things to question, then we will question the information. So when Ms. Mulelekwa was trying to question certain information in terms of how she understood certain things, then there was this, I would call it this office acrimony of saying that this person is not a lawyer. Why will this person look at our work? And I think it went to the extent where they started raising the issue of her not having the legal qualification and not fit to quality assure their reports. And while that was not the first in terms of people not being happy, when the quality assurance team also was assisting the public protector, executive managers also, they started seeing themselves almost like reporting to juniors. That is how the whole thing planned out. And from my observation, that is where the disagreements started. And Mr. Matlawe was very much vocal about the dissatisfaction. And that is how I have seen it unfolding. Thanks.
So in paragraph 14 onwards, well, in paragraph 14, you describe the worsening of relationships when Mr. Matlawe didn't turn up on a weekend when he was required by the PP to attend and quality assure the CIX report. can I just ask, was it expected that employees make themselves available for work on weekends?
Thanks, Advocate, and through you, Chair. Mostly, people are not expected to go to work over the weekend. But if a request is made and the people indicate their availability, that can be accommodated for operational reasons. I remember a public protector asking that because of time, the report needed to be finalized, and there was a request to the quality assurance team. I can't remember whether it was all of them, but Mr. Matlawe, being the lead of the quality assurance team, we were requested to come. I think it was leading towards a holiday of June 16. I can't remember. We were requested to come on a day that was not a work day, and we agreed that we will come, and indeed we came on that day. And Mr. Matlawe did not pitch on that day, but he was expected to come because he never indicated his commitment on that particular day. So to summarize it is not generally expected for people to work on weekends, but for operational reasons, people could be requested to work on weekends, and if they agree, it will happen. And I remember that under the circumstances, they agreed, and other members pitched up, but he did not pitch up on that specific day.
Linked to this, possibly this requirement to work on weekends, which you say was not generally there unless agreed to by employees. Some witnesses will come and testify that the taking of leave was frowned upon in the organization. That leave was often cancelled or refused. Can you comment to this?
Yeah, although I may not be specific, Advocate, and through your Chair, in terms of specific circumstances, but it is a general practice that leave, when you request it, the person who needs to approve your leave, not to look at the operational requirements, whether the operational requirements on that day that you want to take leave do allow. And in certain instances, the supervisor can say, because of what is facing us and the deadlines and all these other issues that might be prevailing under those circumstances, leave can be denied. I'm not sure if when leave is denied, the frowning upon of the leave, I really, that one I can't comment on it, but I know that a supervisor can deny somebody's leave due to operational reasons. That one can happen.
Right. So in paragraph 17, you talk about Ms. Mulelekwa then moving from the private office and back to her position of manager customer services. Why was she moved from the private office back to her original position?
Thanks, Advocate and honorable members. This incident happened quite a while ago. But what happened is the first move that happened is quality assurance was moved out of the public protector's office in terms of it now going back to the executive managers, because the public protector said everybody is responsible for quality assurance of their particular report. So the work of quality assurance is no longer going to reside in private office. So respective members of the quality assurance team were moved to different branches within PPSA in terms of investigations. And the lead, who was Mr. Matlawe, was also moved. If I remember well, He was moved to report to the acting COO during that time. That is where the work was placed. And Ms. Molelegwa, due to certain circumstances that I really don't have much information on, except that there were media inquiries in the space and media reports. And I would also recall in one of the meetings that the public protector was addressing Parliament. Certain members wanted to understand the role of Ms. Molelegwa. I would think that that was the reason why the public protector felt that it will be proper for Ms. Molelegwa to leave the office, and the quality assurance team also to be moved elsewhere. And that is just my observation, but I was not part of how the real move happened. But I know she was moved, and she moved back to, I think, an original position that she had before her acting. Thanks.
Thanks, Mr. Tebele. You've already alluded to the leaking of information and the investigation that resulted from that leak. This is the investigation where Advocate Matlawe, Mr. Neshunzi, and Mr. Kekana were implicated. Is that correct, or investigated?
Thanks, Advocate, and through you, Chair and honorable members. The investigation, from my understanding, when it started as the leaking of information. And the reason why maybe Mr. Neshunzi was singled out was because he was the one that was responsible to communicate with SSA, who were responsible to conduct vetting on our staff. So that particular one, because I think it involved the outcome of the security clearance of the CEO, then the CEO felt that there is a risk in the organization. But when the investigation started, it did not pinpoint to Matlawe and Tebogo, but the person who was the suspect in terms of leaking of the information, because the feeling was he was the custodian of that particular information and nobody else should have known about it, was Mr. Neshunzi. And it was after the investigations that I think the others were involved in the investigation, or Mr. Matlawe and Mr. Tebogo. It was as a result of the investigation itself, but I don't recall that when the investigation started, they were part of the people suspected to be having the information, maybe during the investigation.
Thanks, Mr. Tebele. So in the next section of your affidavit, and we'll spend a bit more time on this section. This is section D, where you've titled it Reporting Investigations Backlog in the PP. And you describe the working environment in the office of the PP. You describe it in various ways throughout this section. So I'm just going to pick you on some of the paragraphs where you describe it and ask you to elaborate. Safe to say that I think it's appropriate to point out upfront here and just confirm that this is your evidence, that you yourself have never been intimidated, harassed, or victimized by the PP, correct?
That's correct.
And that you have never seen the PP intimidate, victimize, harass employees, nor have you seen the former CEO, Mr. Mahlangu, do the same. That is your evidence, is that right?
That's correct.
So just going back to the beginning of this section then, paragraph 21. where you describe the working environment as highly charged and demanding. Can you elaborate, please, on what you mean by that?
Thanks, Advocate, through you, Chair, and honorable members. I am not going to beat around the bush in terms of the demand in the office. And because I have seen it in many meetings that I attended, and I have seen people falling short of giving what is supposed to be given. The work in the public protector is, yes, is demanding on its own. And I think what compounded the problem is a lot of cases that were within the team members that had aged, which means they would have passed their time in which they were expected to have finalized them. And the public protector wanted to deal with those cases, and they were named backlog cases. The backlog cases, in terms of my understanding, is those cases that would have, in terms of the timeline that they were supposed to have been investigated, they have passed their timeline. And the emphasis that the public protector always had during these meetings was put yourself into the shoes of the complainant and tell me if you submitted this complaint in the public protector and this particular complaint remains. Sorry, let me just.
Is that you, Mr.
Sorry about that. The emphasis from the public protector was that she needed really service delivery to be done and to be done promptly. And as such, she emphasized that people should follow the standard operating procedures in terms of dealing with investigations. And I would think that she was really not happy with the backlog that was sitting in the office and things not moving. Let alone the fact that during the investigations, there are complainants which would directly talk to the public protector about their dissatisfaction. So in her trying to deal with the backlog that was there in the organization, to reduce it to the level where investigators can now deal with investigation at their own pace without anybody following them. She put up a lot of programs in trying to deal with that one. And that in itself put a lot of pressure on the investigators. And the public protector demanded investigators to give deadlines in terms of the work that they were doing. I would even remember her saying that, you guys, you are always saying that because I give you deadline. This time, I don't want to give anybody deadline. I would want you guys to give me deadlines. But once you give me a deadline, you must adhere to that deadline. And most of the deadlines that would have been given could not be adhered to. And I would remember, because I was recording those deadlines, there will be matters where you find that a deadline was given in February. And maybe even up to today, for example, the deadline has not yet been met. So you can imagine on a meeting that is happening every Friday, where you need to be asked about the very same information, and you keep on shifting the goalpost. From my understanding and observing how the public protector worked, she did not take kindly the issue of deadlines not being met. And in an institution where you had more than 160 people investigating, you can imagine what, how many deadlines will be there and how many of them will not be met. As such, the work itself demanded more, and the executive authority demanded outputs.
So you then say in paragraph 23 that the backlog clearing initiative then created quite a lot of pressure within the office, as you've just also described it. But you also say in paragraph 23 that before the appointment of the CEO, the executive managers responsible for investigations reported directly to the PP, and that might have exacerbated a highly pressurized atmosphere. So why did the fact that the EMs were reporting directly to the PP exacerbate the pressure?
Yeah, maybe this may not have been put correctly, but before the arrival of the Chief Operating Officer, all the EMs were reporting directly to the public protector. And the way the structure was, the public protector could interact with investigators directly, even if she doesn't need to go through the executive, that executive manager. Because in the meetings that I attended, that the public protector was chairing, EMs and their teams were attending those meetings. And in most cases, information will be demanded from an investigation member, and the EM will have to answer why, in the word of the public protector. But guys, why should I go and deal with your juniors when you guys are there? Because you're not giving me any reason not to deal with your juniors. Now I have to deal with the juniors when you are currently there. So that is the environment that that existed, and I felt that because the juniors did not see themselves in a meeting, I think, with the public protector, during those interactions, I would feel that they were beginning to feel like they're being intimidated to be in that part of the meeting. But I think when time goes by, they got used to the situation where they were beginning to present to the public protector, and also their EMs being available. So it was that type of a scenario where I believed that as a junior, once you start seeing yourself closer to the executive authority, you start to feel that you are much exposed because you thought your senior should speak on your behalf. But the environment in the public protector is the public protector can call each and every person without the rank in terms of the investigation and just demand outputs and demand why things are not moving. So that I have observed it, and I think I'm not the only one, and those investigators can say they have observed it. So that is what happened, and that is what brought everybody closer to the public protector. And I think to the extent that she knew which investigator is dealing with which matter at any given point. Thanks.
So the way we understand the structure, investigators reported to their executive manager, which you confirm was the case in paragraph 24. But you also say in paragraph 24 that investigators reported to the PP directly as well. So when did they report to the PP directly as opposed to their executive managers?
During, thanks, Advocate, honorable members, and through your chair, during the meetings that the public protector would be chairing in terms of checking how far the investigations are, those respective investigators will directly account in terms of the work that they were doing. That is basically what I wanted to mean in this paragraph. So they would not go through the ranks until the EM, but the reports that would have been produced would still have to go through their senior investigators, their executive managers, the COO, and back to the PP. But in terms of checking how far is this type of investigation, PP would also go and request that information from the investigators themselves. That is what I wanted to say. That is in terms of accounting for the work and the update. They would do that, although the production of the information would still go through all of those EMs. That is what I was trying to capture in this paragraph.
So the Friede matter is one of the matters that form part of the motion that this committee is seized with. Were you involved in the Friede matter at all?
Thanks, Advocate, through you, Chair. The Friede investigation, I was not really involved in the investigation because I think when I came in, the investigation, I think, could have been in the Free State. And when it came to the office, I was really not part of the investigation. But what I remember is there was an opinion, I think, that was done. Because in the Friede project, there was this talk about the public-private partnership between the companies that were involved. And I remember an opinion that the Friede investigation, we need to check if there was a public-private partnership in that project. And if I recall, it was Mr. Nemesis, I think, who provided the opinion. I may be wrong, but I think it was Mr. Nemesis who was the senior manager legal services during that time. And because of my exposure and knowledge in terms of triple Ps, he requested me to check the opinion in terms of the public-private partnership. And from the opinion that I saw, and from the information that I gathered from the public-private partnership unit in National Treasury, during that time, the project was not registered as a public-private partnership unit, no public-private partnership project. And as such, it did not meet the criteria of public-private partnership as espoused by Section 60, Regulation 16 of the PFMA. So that was my involvement in trying to see if the project indeed is a public-private partnership. And I said, no, it's not a public-private partnership. And I agreed with the opinion that was given. But the investigation itself, I was not involved.
So Ms. Dendo is going to give evidence in this process. And one of the things that he will talk about in relation to the Friede project is that the PP said that the Gupta leaks must be excluded or were not part of the investigation. Do you recall you being involved in discussions at all in relation to the Gupta leaks and Friede?
Thanks, Advocate. Through you, Chair, I don't recall the discussion about the Gupta leaks and the decisions taken around the Gupta leaks in as far as the investigation itself is concerned. That I cannot recall.
So you don't recall a discussion you may have had with Mr. Ndo where you told him to drop the issue about the Gupta leaks?
No, I don't recall that one. My role in the task team was mostly to take those resolutions that get taken, but the issue of discussing the Gupta leaks, I don't even remember it in as far as the Friede Dairy Farm is concerned. I know the Gupta leaks from the media that it has been expounded, but I don't have any specific reference to Gupta leaks in as far as Frieda is concerned, or the meeting that I would have had with the public protector in which the leaks were discussed. No, not of my knowledge or recollection.
So in paragraph 29, you describe some more what used to happen at certain meetings, and you say in the first sentence, and I'd like you to just elaborate for us what you say in that first sentence, that you've seen the PP reprimand employees when deadlines they undertook to meet were not met. She may well have raised her voice even when work was demanded from you. Can you tell the committee a bit more about that, Mr. Tebele?
Thanks, Advocate, and through your chairperson and honorable members. I think in my explanation, I have touched about this one, but I will repeat, I think, for the purpose of clarity. In the meetings that I would have said where work was demanded, yes, PP would talk about the investigators ignoring their commitments in terms of what they have committed themselves to. And that is the point that she would have been emphasizing throughout in the meetings, to say, what is the use of you giving me a deadline and you go on and not meet the deadline? And I remember specifically her saying that, don't tell me what you think I need to hear about this investigation. Tell me what you are able to produce. And during those meetings, yes, you could see with a sign language that the executive authority was not happy with what is happening. And at some point, you will feel that a particular investigator is being hammered for the work that is not properly done. And in Public Protector South Africa, you have investigations that have been sitting for a long time and nothing would have moved. And that, I think, in itself did not please the executive authority in terms of the investigation not having pulled up their source, I may say. But in those meetings, yes, I was there. I would have had those because I used to be the scriber of a dashboard meeting, which was chaired by the public protector in terms of demanding or looking at investigations and how far they are. So in those meetings, I would have heard the PP's voice in terms of showing frustration and maybe agitation in terms of the demands that she wanted and the outputs, and those outputs not coming. And to me, I took it that it is because of the work that is not forthcoming. Maybe that is why the executive authority reacts the way that she reacted during those meetings. Thanks.
So some of the witnesses will testify that one of the ways in which their harassment and victimization manifested was during dashboard meetings, through the PP compelling them to agree to unrealistic deadlines. Did you observe this at all?
Thanks, Advocate, and through you, Chairperson. My observation is most of our meetings, deadlines were given. Either deadlines would have been given by the investigators, or deadlines could have been given by the executive authority, even if I won't be specific in terms of which matters, because we dealt with a lot of matters. But I cannot comment about the reasonableness or the unreasonableness of those deadlines, because in most cases, you find that this matter has been here for 3 years, and the investigators still need more time. When the matter has already passed it's live. And the investigator still needs more time. So I wouldn't want to comment on the reasonableness or the unreasonableness of the deadlines, because deadlines were given under certain context. That is all what I can say, because it's very difficult to say what is a reasonable deadline if a deadline would have passed before, and what is an unreasonable one. But yes, those deadlines, they were given, others were not adhered to, and not even once, maybe twice or three times. So it did happen. So I wouldn't know why maybe they felt that they were harassed by those deadlines. Maybe those particular investigators could give the evidence in terms of the context under which they felt the unreasonableness of the deadlines. Thanks, Advocate.
Thank you, Mr. Tebele. Before Advocate Mayosi continues, just assist us and yourself. Maybe you can put your phone on silent, or so that you also stop the vibrations, because there's a lot of that next to you there. We're not saying switch it off, because you will need it so that it doesn't disturb you as calls come in or messages come in. It's better when it is in silent. Thank you.
Thanks, Honorable Chair. My apologies. It was on silent. Maybe it is because it was closer. I've put it away.
Thank you.
So if you turn to paragraph 37 of your affidavit, you say that all the reports that are provided are read by the PP, and if they are not in order, they are sent back to be brought up to standard and corrected. What you're saying there, and correct me if I'm wrong, is that the PP will not attach her signature to a final report that she's not satisfied with, correct?
Yeah, thanks, Advocate, and through your chairperson. The knowledge that I have with the PP is she reads the reports, and I've seen it in many instances where reports were sent back for one way or another. But yes, she does read the reports. That is what I can attest to.
And she has the final say, is that right?
Yes, in terms of the report being finalized and issued, the executive authority has the final say.
So if I can take it out to paragraph 44, and specifically the third sentence of that paragraph, you're still talking about the pressures around finalizing the backlog and so on. But you say in the third sentence that you don't dispute that the work demands may have been perceived to be unreasonable. However, this wasn't caused by the PP, but by circumstances in wanting to ensure that complainants' complaints were reasonably and timelessly dealt with. Can you just elaborate a little more about which aspects of the demands may have been perceived to be unreasonable? What do you mean by this?
Thanks, Advocate, through your chairperson and honorable members. I would have talked about this in one of my explanations. The demands of the backlog, we had also to projectize the backlog. Sometimes last year, the office of the CEO was requested to assist the office of the COO to projectize backlog cases. And in that project timeline, we had the end of September as the time in which all the cases that were in the backlog data should have been finalized. And there were a lot of cases that were still there, and a lot of old matters that were there. And there was a rigorous follow-up in terms of those reports in terms of them being finalized. And during those follow-ups, and the investigators would know that there were deadlines that were given specifically to those projects. And they were specifically requested to prioritize and deal with the projects, not as business unusual, not as business usual, but as business unusual, so that the backlog can be dealt with. And after September 2021, then investigators will have the time to deal with all other matters. There were a lot of timelines that were given in respect of those projects. Each and every investigation had its own timeline, and all the people that were involved in that project, which was managed by the Office of the COO, assisted by the CEO, all had timelines. So there were a lot of demands in terms of their time, in terms of the quality. That is how I think I'm reflecting on this paragraph. So the pressure was still not anything new. It was because the matters were old. It was because the complainants were complaining. It was because the executive authority felt that we are not giving the complainants a good service. And as such, the institution itself, people may not have, may not, I don't know how to put it, may lose confidence in the institution. I think that is what the executive authority wanted to say. But in doing that, all those projects, they have their own timelines, but the main thing was their deadline, and the main thing was that they needed to be finalized by September 2021. And everything was around that one. And this also relates to deadlines, relates to the quality that needs to be produced, also relates to the interaction by those investigators with the complainants in terms of the standards that the office has to say you need to contact the complainant within a specific time, you need to do this. So those were the demands in terms of the timelines that I was trying to indicate in this paragraph 44.
Right, taking you now to the end of your affidavit, where you deal with the issue of Audi letters, which has come up somewhat in the testimony of the previous witnesses. You yourself say you received an Audi letter. You say this in paragraph 49, and you say that in paragraph 50 that when these Audi letters were issued, it was because deadlines were not met, promised reports were not delivered. So some witnesses will say that this issuing of Audi letters in the manner in which they were issued contributed to what they will describe as a culture of fear in the organization. Can you comment on this?
Thanks, Advocate. My comment would not based on what I know from those people that will be testifying, but my comment will be based on the implication of an Audi letter. Yes, as I indicated, I did receive an Audi letter, and to me, I was shocked to receive an Audi letter because it would have been the first time, I think, in my career where I received an Audi letter. So it shocked my system, but I understood the circumstances under which the Audi letter was given. In PPSA, there were Audi letters that people would talk about, and I think people said they were complaining about Audi letters, but I wouldn't know in terms of the fear that it created with them. I can talk about my own experience because an Audi letter becomes the first step in a disciplinary process. So when you get an Audi letter, at some point you start to think that my job is on the line. I may be fired because it's the beginning of a a disciplinary process. So under those circumstances, I would think that, yes, they could have been fearful without knowing the exact way in which they felt. But I'm talking about an Audi letter, which is a first step of a disciplinary process, because without an Audi letter, it means you are not going to be disciplined. But once you start getting it, it means you are beginning a process where you might face a disciplinary hearing, and then you never know what will be the end of that. So under that circumstances, yes, people could be fearful about an Audi letter. But I'm not talking about those people in terms of how they have indicated in their affidavits. But that is what I know an Audi letter to be in terms of an HR process. Thanks.
So, Mr. Tebele, you stand by the contents of your affidavit, correct?
Correct.
It was drafted with the assistance of the evidence leaders after consultations with you, correct?
Correct.
And in that process, various drafts were sent to you for your final approval before you signed it before Commissioner of Oaths.
Correct.
Can I just ask, Mr. Tebele, did you know the PP before you joined the PPSA?
Yes, I've known the PP from our university days.
There's one final issue I just want to approach with you before I let you go, Mr. Tebele. Bundle F, item 69. So this relates to the testimony that Basani Baloy, the former COO, is going to give. She will testify that on the 18th of February 2019, so soon after she started at the PPSA, she received a text from the PP that reads as follows: COO, careful of what you hear from Bona and Tebele, but you're an adult, be wise. She'll of course say she interpreted that to mean that she should not trust you. But my question to you, do you know of any reason why the PP would issue such a warning about you? Do you know what this related to?
Thanks, Advocate. Well, it's for the first time that I see the note, and throughout my working in PPSA and working with the public protector, Advocate Mkhwebane, I've never created an environment where I believe that I would have been not trusted. But I will leave it up to the public protector, because I wouldn't know why she said what she said, if it's her who said what she said. I've always believed that she trusts me, and even today, I still believe that she trusts me. And not only her, but even the CEO that I'm serving under. So I see myself as a person who can be trusted in the institution.
Thank you, Mr. Tebele. Chair, I have no further questions for this witness.
Thank you, Advocate Mayosi. Mr. Tebele, just to get a clarity quickly from you before I proceed to the next point, did I hear you say it's the first time you see this note?
Yeah,
meaning, yes, Mr. Tebele. Please, Advocate Mpofu, don't disturb me.
I'm sorry, Chair, I thought I was muted.
Okay,
yes,
please mute Advocate Mpofu.
I'm not aware of this note that I'm seeing now.
And you've never had on your phone this message?
Unless it was sent today.
Okay.
but not before today.
Thank you, Mr. Tebele. Thank you.
Chair, if I could clear that up.
Yes.
It was in fact sent to him today, earlier before the hearing.
You sent this note to him
Mr.
today before the hearing.
Correct.
Probably has not checked his phone.
We discussed it.
You discussed it with him?
Yes.
Okay.
I was warning him that that would come up so that he wouldn't be surprised.
All right. Let's take it, I think, because that would happen today, because that's what he said. He did not see it before today. Am I right, Mr. Tebele? That could have been in the morning and so on.
Yes, Honorable Chair.
Okay.
It was brought to my attention today.
Thank you, Mr. Tebele. Honorable members, the time now is just 27 minutes past 11. We're going to take a break and be back at 1:45. We pause here. Thank you.
Recording stopped.
We now resume and proceed with our session. I'm just gonna check if Advocate Mpofu, if you available, you there?
Yes, I'm back, Chair.
Thank you. I now hand over to you, Advocate Mpofu, for your cross-examination.
Thank you, Chair. Thank you, Chairperson. Good morning, Mr. Tebele.
Good morning, Advocate Mpofu. Percy.
How are you, sir?
I'm okay.
Good, thank you. I'm fine too. I'm going to just ask you to deal with some of the topics that you dealt with Advocate Majosi. But before I do that, I just want to start where you left off. You are sure that this SMS that you are shown here, you only saw it today, this morning, for the first time?
Yes, it was shared with me for the first time today.
And you don't know, I suppose you don't know when the evidence leaders obtained it from Ms. Baloyi?
No, that I don't know.
You were not told?
No, they didn't tell me when did they obtain it. It came today, almost before the start of the session.
A few minutes before the start of the session?
Yes.
And were you told that it came from Ms. Baloyi at least?
I was told that it came from Ms. Baloyi, and according to Ms. Baloyi, it came from the public protector.
Yes. You were not told if any investigation had been done to ascertain whether indeed it came from the public protector?
No.
And because I heard you saying, even in your response, that if it came from the public protector, it's surprising to you because you always had a trusting relationship with her. Is that your evidence?
Yeah, what I was indicating is I've always, maybe from my side, thought that the public protector can trust me or is trusting me. And even now, I still need to believe that.
Yes. Yes, thank you. That's what I'm coming to. So despite this last minute, springing this last minute SMS on you a few minutes before you gave evidence, you are not shaken in your belief that there's a relationship of trust between you and the public protector?
No, from what I saw, the SMS, I think it's dating back. I'm not sure whether it's 2018 or 2019.
19.
And since after the SMS, I've been in the institution. And I think one way or another, I would have met the public protector, and I did not see any indication or get anything to the contrary.
Thank you. And in any event, despite what was being said to you, there's nothing in the SMS that says the public protector does not trust you. Those were words that were put to you, correct?
Yeah, except the words that I saw, I didn't hear anything in terms of verbatim from the public protector.
Yes. Yeah. Anyway, I'm sure we'll hear something about that from the evidence leaders as to why that was the case. Let me just hold on one second. Yes. Okay. No, because we were surprised. It was sent to our team yesterday around about 9 p.m. So it was not sent to you that time?
No.
or any time last night?
It was sent today through a WhatsApp note.
Yeah. Okay, please, if you can just maybe during the break, just check the time that it was sent to you so that we can compare it to the time that it was sent to us and see what was the duration, the gap between the two, because otherwise it's something we might have to report to Parliament as an anomaly. Yeah. But be that as it may, let's not be distracted by that. Okay, maybe just the last thing on that. You don't know what that conversation was about, whether it was about a particular report or whatever, or football match. You don't know?
No, I've got no idea. What was it about?
Okay. No, thank you very much. All right. Now, you've testified that you've known the public protector for a long time. And is it correct that you've also known her as a hard worker?
Yes, I've known the public protector for a long time. If I'm not mistaken, it's more than 30 years.
Yes.
Yes, and knowing her from our school days, yes, I know she has been a hard worker.
Thank you.
And knowing her from other maybe areas that she was working, because we used to have some communication at the time that we could. She has always been a hard worker
yes.
person that I came to know.
Thank you.
And seeing her in action here, yes, I thought she demonstrated that aspect. That is what I saw.
Yes, no, that's the point I'm making. Yes, but for someone who has known her, you were not surprised, you in person particularly.
No, I was not surprised.
Yes. Before we get into this specific, your experiences at the Public Protector's Office, I just want to take advantage of you, if you don't mind, because you are a person who can assist the committee. I sensed that there were some kind of misunderstandings around the framework, or let's call it the PFMA world. Yeah, I've worked in that world. I was once an accounting officer and accounting to Parliament. So I would have expected the evidence leaders, I can understand if they're not familiar with that environment, but I'm sure the members hold many entities to account. So I just want us to go through some of the framework issues. And also you have an advantage because in the PP's office, you've worked both on the side of the executive authority and now you are on the side of the accounting officer. Am I right?
Correct.
Thanks. And on top of that, you've also had experience at Treasury, which also is, well, that's the home of the PFMA. Correct?
Yes, correct.
Yeah. Okay. Now, there seemed to be some sense that there are what one might call Chinese walls between the roles of these offices. Am I correct that there's a lot of convergence between the role of an accounting officer, who's usually the CEO, an accounting authority, who's usually a board of directors, if it's that kind of entity, and the executive authority, who's usually the minister?
I think the distinction of those roles, it goes with an organization.
Mhm.
In a pure government department, not everybody gets to see the minister.
Right.
The DG, we get to know the DG. Others get to meet the DG, others not.
Mhm.
In the case of a public protector, that is where I found a little bit of a shock.
Mhm.
It's the role of the incumbent. It's almost like becomes an operational one.
Mhm.
In as far as the investigation is concerned.
Mhm.
Because the investigation, almost when you go through the PP Act, rests on the shoulders of the executive authority,
Correct.
which make it different to the environment that I was used to. And when I started seeing the operational nature of how the executive authority was, during my early days in PPSA, the accounting officers were not even attending our meetings that were chaired by the executive authority. It was later on that they started coming, and I was surprised why.
Mhm.
So I start to understand that maybe the accounting officer of the institution is purely and solely responsible for the accounting in terms of the PFMA.
Mhm.
And my understanding was that the executive authority takes charge of the investigation. That is how I understood it all along. And without understanding how did they separate the accounting officer from the investigation. And later on, the executive authority started bringing in the accounting officer into the investigations. So that is what I observed when I came here. And I was also surprised, why is the public protector to me look to be so operational? But then I understood it that the investigation is at the core of the public protector.
Responsibilities, yes. Good. And then maybe in that mix, you're quite right, the PFMA itself is quite flexible about the type of entities. So the configuration that you will get in a government department is not going to be the same as the configuration you'll get in a SOE or in a provincial department. Even the SOEs, there are Schedule 1 and Schedule 2 and all sorts of different configurations. So the PFMA is flexible enough to accommodate all those different types of entities. Isn't that so? Is that so, Mr. Tebele? I think you're frozen. I was just asking for you whether to confirm or dispute what my summary of the PFMA.
Thanks, Advocate. We both through you, Chair. Although the audio was a bit delayed, yes, there are different roles that the PFMA is putting in terms of the accounting authority, accounting officer. Those roles are clearly spelled. And it became difficult for me because the institution that I'm serving does not have a board.
Yes.
So without a board, then the accounting authority becomes the executive authority, in my understanding, without the institution having a separate board.
Good.
But there is a very thin line in terms of where does the accounting officer stops and where does the accounting authority starts, executive authority starts. I think that one I really don't know. if I may put it. It's only my experience that will come into play, but PPSA has a different way of handling it, especially when you have to marry the Public Protector Act and the PFMA. That is where the difficulties I think I'm experiencing, but there are those different rules.
Thank you very much. Yes, that's exactly what I was getting at. So the lines are blurred. Well, they are normally blurred anyway, in the sense that those three entities interact. But the point I was making, which I think you have touched on, is that those blurred lines are even more pronounced in an entity such as the PFMA, where there's no separate accounting authority in the form of a board. Correct?
Correct. Maybe I need to qualify that, because in terms of the PFMA, when coming to finances, the executive authority does not play much of a role in terms of how the finances work. Is the accounting officer. But in terms of the Public Protector Act, there is still this that the public protector is responsible for that part of the investigation. And when you look at investigation is part of the organogram of PPSA, which under normal circumstances should have been clear in terms of the accounting officer and the accounting authorities' roles being different.
Good. Okay, thanks. Yeah, no, thank you very much. I think we will canvass it with other witnesses as well, but I think that is sufficient to just try and explain some of the complexities and peculiarities of the entity that we're busy with, and for those to be borne in mind, hopefully, when we go forward. All right. Now, let's then come more into the specifics. You were tasked with communicating to Mr. Neshunzi about his, let's call it redeployment, correct?
Correct.
And this was against the background of the, let's call it the leakage, the information leakage crisis, which hit the institution, correct?
Correct. It was after the report, I think, was tabled before the leadership.
Yes. And in your observation, Mr. Neshunzi, how did he take the interaction between you and him?
He wanted to be provided with reasons why he should not go back to his office or his original post. And my advice to him was I was requested to ask you so that you know that the leadership is intending to move you to another unit. And I did have a talk with him as the person that I got to know when I was working in the institution. And because Mr. Neshunzi was not really directly reporting to me, in as far as the security issues were concerned, he was mostly accountable to the executive authority and the accounting officer. So I took it that is how it needed to be done. I was just responsible in terms of the operations, in terms of how the security unit need to function when you look at the operational plan. But these other issues, I thought maybe they would have been beyond me. Yes. But when I was asked to consult him, I called him into my office and I talked to him. He indicated that no, he needed to be provided reasons I said, from where I'm sitting, I don't have the reasons because I was not given the reasons, but I take it that there are reasons behind which I'm unable to tell you. And he requested me for the report. I said I did not have the report. And I understand because when the investigation was done, also my laptop was taken. So I did not want to be much involved because I could have been under investigation also.
Yes, good. Yes, in fact, yeah, let's take it from that stage. It's correct, isn't it, that for an institution such as the PPSA or the Office of the Public Protector, the institution, a crisis such as this one would have been a very serious one because you deal with sensitive information, correct?
Yes, there is sensitive information that has been happening, and I would take it that maybe leadership looked at that, and I really did not need to know why did they want to move him, except that I needed to consult with him, of which I did, and I even suggested certain areas where he could be utilized, and I think at the end he moved out of the unit, and I did not get an indication that in continuing to work where he was still not satisfied.
Yes, thank you. And in that world of intelligence, there is a code known as a need to know basis, but you may not know about that. Yeah. The issue here is that once there was an outbreak of leakages, as you have just mentioned, it had to be investigated, and even someone like you was part of the people who were targeted for the investigation, correct?
Yeah, without being specific in terms of why my laptop was taken, I suspect that there is something that they needed to check on my laptop, because I wouldn't understand why my laptop was taken, except that they needed to look at something.
Yes. And you are aware that other people's laptops were also taken, for example, Mr. Kekana, correct?
Yes, I'm aware.
And I think it's common cause that Mr. Neshunzi was cleared after that investigation. In other words, he was not found to have been the person who leaked the information, correct?
Without me having seen the report, advocate, I would say, well, for now, I don't know what was the outcome of that investigation.
Okay, fair enough. But you're not aware of Mr. Neshunzi having been charged, for example, in connection with leaking information yourself?
No, upon his coming back, the matter never continued.
Thank you. You are aware, or if you are, you are. If you're not, you're not. That Mr. Kekana, on the other hand, was charged or appeared before disciplinary processes in relation to information leakage.
Yes, I became aware that he was charged for information leakage.
Thank you. And now let's talk about were you already at PPSA during the days of something that was called the think tank, or did you get to know about it?
Yeah, the think tank happened when I started at PPSA. I think there were about 2 or 3 meetings of think tank, which I attended before the discontinuation of the think tank.
Yes, and thank you. And it was discontinued by Advocate Mkwebane, correct?
Yeah, during that time, if I remember well, without knowing the exact reasons from the PP, the think tank was coming after a long time. It was sitting quarterly, and the public protector wanted to release reports frequently. So from what she was saying is, by the time the think tank sits, some of the reports would have been with her for the last 3 months. So the institution itself did not create a seamless process in terms of the reports. Then she said it's better if the quality assurance aspect, because think tank was part of the quality assurance. If quality assurance can be done at those levels of the EMs, and the quality assurance unit will be the last one to go through this quality assurance. And I think, if I recall well, was when the institution was under financial constraints, because the think tank was attended by also the provincial representatives, and they will stay here for a longer period, depending on those days, because it will normally take 2 days. I think also cost came into play in terms of cost containment. But I think the main thing from what I could gather was that the think tank itself could not add value in terms of the timelines that the public protector would have wanted to issue reports.
Yes, thank you. Right, and yeah, we're told that this think tank dates back to the days of the public protector Mushwana or even Bakwa, but the public protector Tulima Donsela found it there and she just continued with it. But public protector Mkwabane, as you say, saw it fit for the reasons that you have explained to abolish it, correct?
Correct.
Right. And to put it crudely, if a report had to come, or rather, let's start here. The think tank, as I think you've testified, that it was replaced by a weekly meeting of quality assurance, which was centered around the QA function within the office of the PP. Am I right?
Yes, the task team that was happening weekly, was also happening during the time of think tank. Think tank was still there, but the task team was happening weekly, so that the public protector can, on a short-term basis, check where are things in the investigation pipeline. Yes. The think tank was a report, a quality assuring report, and giving inputs towards the end when the report is supposed to be released. But because I think the public protector wouldn't have wanted to issue a report after a quarter, she thought it fit that the report be issued as and when they get finalized. As such, then they had to go through the quality assurance, which was sitting in her private office before it was moved out. And the belief is, in terms of the quality assurance manual that was there were indicators in terms of how reports should have gone through, because the institution had a quality assurance manual and had a quality assurance unit. So that unit would still be responsible for that function of assisting the public protector in quality assurance. But I think some of the things that was emphasized in the meetings that I attended was that things should not be left for the quality assurance. Quality assurance should be dealt with at the level where the investigation is done, and all the EMs need to certify quality on their reports. And there was a certificate that was proposed, which after you have quality assured the report, you will have to certify that the report meets the quality standards, and it goes through the processes. And I still believe maybe that that is still there. I'm not sure for now. But those were the indicators that were there during my stay and in that office.
Thank you. And the certificate you refer to is what became known as the certificate of compliance, correct?
Yeah, I think it's that one.
Thank you. Right. So in a nutshell, if we want to summarize the situation, then what happened is that the quality assurance process, broadly speaking, used to involve this quarterly meeting, but now it was, for lack of a better word, collapsed and condensed into a much sharper quality assurance function centralized in the office of the PP without the quarterly element, correct?
Yes, if I may put it, the think tank which was there, quality assurance was the secretariat to the think tank, which means when quality assurance is ready with reports, those reports get tabled to the think tank. And that is the process that was done away with. But then the quality assurance, the other structure that remained, except that the think tank could no longer sit.
Yes. And in other words, previously a report could not have been released without it passing, quote unquote, through think tank. And now that was no longer necessary, correct?
Yeah, the reports that were issued when think tank was still around, they were going through the think tank.
Yes.
And I think the other thing was that when the think tank sits, you'll find that these reports are still not ready. And they have to go back. And then when they go back, then another think tank is going to sit in 3 months' time. Then it takes about, 6 months for that report to be issued. And I think that was perceived or almost like it's a red tape that is not assisting the institution in terms of releasing reports as and when they were supposed to be issued.
Okay. I mean, and you would agree with this. This is just an example that I'm making. If, let's say, a report, when it was almost ready, if it had to go through 4 quality assurance stages, with the task team approach, it would go through 4 weeks, in other words, 1 month of that process. But with the think tank, it would be a full year because it would be 4 quarters, correct?
Through you, Chair and members, let me put it this way. The task team was sitting weekly, and we were only looking at Section 7(9)s and investigation that have reached report stage.
Yeah.
So it was a much quicker process.
Yeah.
And during the think tank time, when it has passed through the task team, then the quality assurance, who were part of the task team, would take it to think tank in terms of the dates in which they are there. But the timelines in terms of think tank and the task team, they were different because I think they were meant not to be the same. Think tank, it was to bring all the brains of the public protector to the institution to say, what is this report? And the task team was to hold those people that were responsible for their Section 7(9)s in terms of the timeline. And there was still another structure called the dashboard, which we were having every month, although dashboard was looking at a lot of issues. But yes, think tank, if you follow the think tank process, the issuing of reports in terms of monthly would not have been possible under the circumstances.
Yes, no, I think we're on the same page. In other words, I'm saying, let's assume for a minute some problem was identified, and then it had to go back to the next think tank, and then another problem is identified, or the same problem, then it has to go through another think tank, and then maybe after 4 attempts, it is sorted. That process would have taken a full year because the the think tank would only sit 4 times within a full year, correct?
Yes, the other problem that was discovered in the process was when think tank sits, it will be provincial representatives and executives. And you'll find that the person who is presenting the report was not the initial investigator. And some of the issues that are in the report, you find that they are not familiar with. And then the public protector extended the think tank to the investigators to say, if you have been investigating and your matter is going to serve in think tank, you need to come because you are the one who has been investigating. And during the last days of think tank, investigators would come and present their reports in think tank so that we cut the timeline in terms of referring reports back and forth.
Okay, thank you, Mr. Tebele. And as I understand it, just again to assist us to give us a picture, you've already testified that one of the innovations that the public protector introduced was exactly that direct interaction with investigators, not necessarily only through their executive managers, correct?
Yes, although myself, I was not for that idea, but I take it that because the public protector worked in this institution, she had a better understanding of how things should be done. And in that way, she would have been assisting in terms of moving the pipeline. So that one she did. And I think that is where other investigators started having problems of having to face the executive authority, which maybe before they never thought they could do.
Could happen, yes. And by that you mean because the public protectors, in her own experience, she had been an investigator herself. So you deferred to her knowledge of the institution. Is that what you mean?
Yeah, I thought by doing that, it means it's because she knows the institution and she knows how it works. So if you go back, she will assist the investigators in terms of bringing their matters. But I think because of the backlogs that were there, the whole pipeline got frustrated.
Thank you. And am I correct that when you say she was interacting with investigators, you don't mean that there was a big room with all the 160 investigations and investigators, but if an investigation that I was working on was being discussed, then I would be invited. Is that how it worked, more or less?
Yes, during think tank, that is the proposal that she brought in to say, let me get the investigators that were investigating the matter. And then during the report writing also, because she understands and she knows the people that are investigating, she could call them with their names. She knows them that you have this matter. So those interactions, they happened frequent, even during the meetings that we were sitting with. Investigators would present their own matters to the public protector, even if their EMs were sitting in that particular meeting. Yeah. That is how the structure started working.
Thank you. And therefore, because of this, let's call it, she had now had a bird's eye view on every investigation. Did that make it easy for her to monitor and to set the deadlines as you have indicated in respect of each? In other words, there might be different deadlines for a different investigation because she would have had intimate knowledge of each investigation, at what stage it is, when did it start, and those kinds of things. Correct?
The public protector had an understanding of the matters that she needed to deal with, and she had a better understanding of the people that were dealing with those matters. Because in the matters that we are dealing with, you have what we call special attention matters, which are matters that are sitting with the public protector, where she would want to know what is happening. And there are these EMEA matters, which mostly are coming from parliamentarians. And those are matters that were close to her to monitor. And there will be these other matters that have been sitting in various stages of investigation that she may pick. Other matters, she will pick them through people complaining to her directly that my matter is not moving. But she had a list of matters that she would want regular feedback on. And those meetings, she would put deadlines, and she will either put a deadline or people themselves will put a deadline, and that will be recorded. Then in the next meeting, then people get accounted in terms of what deadline did you put, how far are you with the deadline? Because I was also responsible during the task team meetings to put those deadlines which they agreed on during the meetings.
Yes, thank you. Yeah, in fact, let's just touch on that quickly, because there was some suggestion that the deadlines were unreasonable and so on. Did I understand your evidence correctly that the PP even went so far as to ask people to impose their own deadlines on themselves?
Yes, that happened in the meetings.
Yes, and so when she was now demanding the meeting of those deadlines, it would be a deadline that effectively you have set for yourself. So the reasonableness of the deadline would depend on you, as it were.
Yeah, for those deadlines, because that one, I can attest to it, where she said, please, before I give you a deadline, guys, can you put your own deadline so that the deadlines don't come from me? Yeah. But what she emphasized is, if you put a deadline and you don't meet the deadline, what do you want me to do?
Yeah, okay, thank you. No, that's very clear. Okay, now, with your experience, I'm now moving to the issue of quality assurance generally that was canvassed with you. I don't want to go into you've demonstrated that you had a lot of experience in quality assurance generally, and I like the examples you made, because quality assurance in an organization includes, as you said, the style, the technical issues, the language, the editorial, sometimes even you still even get people who are specialists in language to make sure that it flows and all those kinds of things. Now, with your experience in quality assurance dating back from your days at Treasury, would it be correct to say that the quality assurance process at the PP's office was very thorough and produced good quality reports?
In terms of the process that each report should follow, I would say the process allowed the thoroughness of the report at the end. Yes. Because the quality assurance starts with the investigator after drafting. It goes to the senior investigator, it goes to the executive or the chief investigator. It goes through all those processes up to the level of the public protector. And for me, if it goes through that process, then there is still thoroughness. And if there are mistakes, then it means then it's just a mistake that would have happened. But that is the process which the reports were going through. And I still believe that even now is the process that the report are still going through.
No, thank you very much. Yeah. Because the impression that's given out there in the world is that, these reports are scribbled by the public protector in the back of some matchbox, and then released to the public. So with that thorough process, do you agree that it was mostly guided also by what you call the template, the agreed template of the organization, correct?
Yes, the quality assurance unit had a template in which a report should follow in terms of the style. And their responsibility when they quality assured the report was to look at the template and the style. They knew how to do it. I don't know if currently the same style is still being used. Because there is still quality assurance unit, but I'm not sure if they still follow the manual where you give them a report. There is stage 1 of quality assurance, there is stage 2, there is stage 3. There were different stages in the quality assurance process. So currently, I can't attest if that is still being followed. But during my stay, that is how quality assurance was done.
Yes. No, the public protector will testify that with a few improvements, that is still the same process that is followed, and that the standardization itself is a way of assuring quality, because then people get used to how it works. Would you agree with that?
Well, I'm not sure of her testimony, but what I just indicated, it's what happened and what I'm aware of during my period while I was still in private office, interacting with investigation and quality assurance.
Yes, no, sorry, Mr. Tebela, maybe the question was not clear. I was saying, would you agree that the whole issue of standardization, I'm talking now in terms of quality assurance theory in general, the issue of having a template and standardization itself contributes to quality, because people get used to the style that is expected and are able to refer back to previous reports and that kind of thing.
Yes, the template is standardizing how things should be done.
Thank you. Now, when you were saying that within the office some tension arose, and I can assure you I know what you're talking about, between lawyers being asked to report to non-lawyers and that kind of thing. In that equation, the non-lawyer was Ms. Molelekwa, correct?
Yeah, correct.
And the lawyers were Mr., or at least the people who regarded themselves as lawyers, were Mr. Kekana, Mr. Matlawe, and Mr. Well, mainly those two. Were there others who were lawyers? And I suppose yourself, you are also a lawyer.
The quality assurance unit, which was headed by Mr. Matlawe, was mostly lawyers. Mm-hmm. And the quality assurance, by virtue of the unit being in private office, and by virtue of Ms. Molelekwa being the chief of staff, which means she was the most senior person in that office.
Yeah.
Things in terms of protocol needed to be sent through her.
Yes, thank you. And that's what caused this tension.
Yes, when they thought that she is now making inputs in terms of law and investigation. I think that is where the whole thing started from what I could remember.
Yes, no, fine. No, I know the snobbishness of lawyers sometimes. All right, and then at what point did Mr. Matlawe go AWOL and just not pitch at the agreed weekend meeting? Was this in the middle of this, let's call it disgruntlement about pulling rank and all that?
No, the issue of Mr. Matlawe not pitching happened in June 2017. I may not be exact in terms of the date. Mm-hmm. Can't remember whether we were supposed to sit on the 13th but there was a holiday, and then we needed to come and assist the public protector to finalize the report, which was called the CX. I was a week and a half in the institution. There was no issue of disgruntlement during that time. I think it became just an issue. Maybe he just got committed somewhere, and then he did not come for that specific meeting. But those that were there, Bokekana and the other quality assurance team, they assisted the public protector to finalize that report.
Yes, I think.
It was not in the middle of what happened after.
Okay.
Because
No, I think.
still after that period, the quality assurance unit still continued working in the office of the public protector,
Yeah.
even after that happening.
Yes, no, that's fine. I think, yeah, Mr. Kakana's evidence was actually that because of Mr. Matlawe's absence, he himself took the final report to the public protector, and I think that was confirmed in an email which we showed him, which came from the public protector. All right. Now, if we move to then the issue of backlogs. Well, first, before we do that, let's talk about the issue of just deadlines correctly. You said you had no qualms about agreeing to the fact that there were many deadlines set and people were, squeezed into meeting those deadlines. But your evidence is that this was done for the sake of the public. In other words, to deliver to the complainants, correct?
Yeah, from the meetings that I attended and the interactions that took place in those meetings, the issue of putting the complainant first came very high, and the issue of following standards in terms of when to issue reports also came very high. And that was the emphasis to say, how do we justify having a report or complaint that is sitting with us for 6 years? Because it means we are also inflicting secondary prejudice to that particular person. I mean, those were some of the words that the public protector will attest.
Thank you.
And the problem is the deadlines, because people had a lot of issues that they needed to deal with at the time the public protector wanted them. They could feel that maybe it was not reasonable for me within this space of time with 20 investigations to push them all. But I'm not speaking for them, but that is what I think would have went into them. But it was not because the deadlines were not done for the sake of producing the reports. The deadlines have always been about producing and completing the reports and getting rid of the backlog.
Thank you. And another impression was created by a Mr. Samuel, if we can even take anything from anything he said. And it was that the deadlines were, in a way, just time related. In other words, you must produce this next week, but there was no focus on quality. But from your evidence, that it seems that there was a balance between meeting the deadline, but also meeting the required quality standards, correct?
I think I would need to qualify, although Mr. Samuel has been in the institution, I think more than my days, he would understand better. But having been close to the investigation team, the problem was that the age analysis in terms of investigations was just getting too wide. And the public protector was feeling that we are really not doing justice. And if you sit with matters, let's say you are investigator A, you have 15 matters with you. And in these 15 matters, 10 of those matters should have been finalized 2-3 years ago. And you still have them. And you are going to be pressurized today because those things are long overdue. Yes, you will have a feeling that I'm unreasonably being treated. Or if the investigation moved from another person to you, but it's old already and the pressure goes to you, naturally you will have a feeling that this is becoming unreasonable to me. I think those will be the context under which it would have happened. But I think Mr. Samuels is in a better position to put it more clearly. But my observations were that when the public protector demanded that these things be finalized, they were already long overdue in the hands of different investigators. And the timelines were, I mean, if something is long overdue 2 years ago, yes, if I come today, I say to you, produce it tomorrow, and you have not even started, you will feel the same way.
Yeah. Mr. Tebel, the question I was asking you is, did those deadlines go with compromising quality or not?
A deadline.
In other words, was it, look, just produce this thing next week or next month or whatever, and it doesn't matter what quality it is, even if it's shoddy work, we'll take it and then we'll tick the box and say you've met the deadline. Or were the deadlines also, you had to produce, still had to produce good quality work, correct?
From my understanding, the deadlines did not cut the corners.
Yes.
In terms of the quality. The deadlines and the quality assurance processes still needed to be met.
Yeah.
But maybe it's a question of how many deadlines do you have, and can you produce the quality within that deadline?
Yes.
Whether the deadlines impacted on the quality of investigation, that one I'm unable to.
Yeah. No, from what you okay, but from your observations was okay. Well, let's put it this way: if there was no insistence on quality, then everybody would meet the deadline because you could just produce anything in 3 days or whatever. Surely the reason why people felt that they needed longer deadlines, or that they, or rather that they came back to say they have not met the deadline, must have had something also to do with the template. In other words, they still had to meet the requirements of quality and a good quality report. Surely, am I correct?
I would want to qualify it, counsel, this way, because a deadline and quality, sometimes, yes, a deadline can compromise quality. It depends on when do you start. Mm-hmm. If I give you a deadline today on a matter that you have been sitting with for 4 years, and you did nothing, obviously you are going to rush to meet my deadline. So the investigation itself could be compromised. Not because of my deadline, because of something that happened before I gave you the deadline, because the matter was never attended to. So the issue of quality and deadlines, to me, they may not be the same. I can still produce quality when I still have a deadline, or I can get a deadline, and because I'm far away from the investigation, then I'm just trying to put something together quickly, so that I can meet your deadline. So it's becoming your deadline that I want to meet. So it depends on different circumstances, if I may put it that way, because I don't know the circumstances that is prevailing now with the investigators, whether the deadlines that they are getting are the reports that are still active, that has not gone beyond their timelines.
Yes.
Because I believe that some of the reports where they get the deadlines, they've already gone beyond their timelines. There could be those reports that have not yet gone beyond their timelines, but for different reasons, the executive authority would want those reports to be finalized.
Yes, thank you. I think in short, you would agree that once the person producing the work produces it, it would still go through the normal quality assurance unit in the PP's office. Am I right?
Yes, it will still go through the normal quality assurance processes within the institution.
Okay, good. Now, You've also spoken specifically about the issue of backlogs and age analysis, I think, as you call it. And in fact, just in one example, Mr. Samuel himself was involved in a report which had been sitting for something like 3 to 4 years. So in those kinds of situations, you would agree that that is thoroughly unfair on complainants, correct?
I think as a way of putting it, it's when a complaint gets given, the complainant is expecting something to be done, not after this longer period. Yeah. Yes, in the PPSA, we have guidelines in terms of after classifying the matter, after how long are you given time to deal with that matter. But I don't remember where a guideline is saying you can still do the matter after 4 years of receiving it. So these are the situations that are there in the institution, which if cases can be analyzed, you will still find those that are way back, which the backlog project was trying to get rid of so that they start on a clean slate. I mean, I know that the backlog project had a timeline, and many people, because of the overwhelming nature of the work that they still had, they could not deal with that backlog project. But that did not take away the timeline that the investigation required.
Yes, Mr. Tabel, let's call it the grand deadline of the backlog project was September 2021, correct?
Yes.
And therefore, obviously, depending on report to report, the smaller deadlines or the build-up deadlines would be different, but all of them to converge on the big deadline of September 2021. That more or less that was the configuration according to the public protector. Can you confirm that?
Yes, the project that the public protector requested the COO and the CEO to do had a deadline of September, and within them there were different dates in which the investigators should finalize their matters.
Yes. So in other words, if I was sitting with a report that was 2 years old and you were sitting with a report that is 4 years old, our deadlines might be different, but we must all be done by September 2021, correct?
Correct. They have different timelines, the projects.
Okay. And do you know, or were you ever able to diagnose what caused the lethargy of the past before Advocate Mkhwebane came into office, so as to have this laissez-faire approach where reports could sit for years and years without being completed?
No, I don't really know what could have been the cause. But in the institution, you always have reports, you always have complaints that you carry forward in every financial year, which you would not have been dealt with in the past financial year. So I think that works for each and every public protector. I don't think that you'll ever get a public protector who will come here and start on a clean slate. There is no such, because complainants, they come every day. They can come on the last day of the current public protector and complain. So that becomes a balanced brought forward. But I have not analyzed what could have been the reason why certain reports were not done previously, because I don't know what was the mode of operation in the previous public protector. But what I could know is the number of reports that they were issuing before and the number of reports I think that we are currently issuing. There is vast difference in terms of the numbers. I'm not talking about the quality or the whatever, but in terms of the numbers.
Yes. Yes, no, that's exactly, you've answered my next question, which is whatever they were doing right or wrong, because you are not there, you cannot say, but what you can safely say is that the numbers have improved significantly, correct?
Yes, the numbers have improved, and one of the things that the public protector did was to say, I have 160 something investigators, and why should I produce smaller reports? And she started saying the following people in the value chain of investigation, they should also produce their own reports. And I think that upped the numbers in terms of the investigations, and the numbers went up.
Yes, and you, again, having sat on both sides, you also can confirm that the overall administration also improved in the sense that you had 2 clean audits in 2 successive years, something that was completely unprecedented in the 26-year history of the organization, correct?
That's correct. The emphasis that I got when I was in private office, and that is, I think, what the public protector would have wanted to inculcate. I'm not sure if I'm still audible because I can't.
Yes, we can still hear you.
You are still audible.
Thanks, Honorable Chair. The issue of compliance of the institution, I think, was at the heart of the public protector in terms of what we needed to do. So the issue of the institution having to comply with all the regulations, it was at the heart of what the public protector kept on preaching. And I think that is where our standards started to improve in terms of where things were. And the efforts of the former CEOs also started assisting in us going to the right direction. And I think because when I joined the institution, the audit outcomes, although we still had an unqualified, but there were a lot of matters that were sitting. And we established quality assurance teams to check the finances. We had an audit steering committee under the leadership of the current public protector, and there was a budget committee that was set up. Those institutions that were set up, I think, ultimately made the institution to start realizing the clean audit in terms of administration. That is what I can just attest to.
Yes, thank you. And I can also attest to, even though I'm not a witness here, that the worst thing you can do is to sit on a clean audit and congratulate yourself forever. As you say, you have to attend to all the issues that might have been pointed out by the Auditor General if you are going to achieve another clean audit. Would you agree with that? In other words, in order to achieve another one in a successive one, rather than just basking in the glory of one clean audit. It's important to make sure that there's continuous improvement, correct?
There is continuous improvement, and you need to maintain those certain standards that you had and improve on those standards. That is how you can maintain a clean audit. you don't need to relax because you have a clean audit. You need to improve the standards because the audit also improves every year. You get different auditors that audit you differently every year. So if you don't improve, you are likely to regress.
Yes, thank you. Yes, and just by the way, this is something that my team has been worried about regression, not just for their own ends. You know that one of the standards to meet in order to achieve a clean audit is the rate at which you pay your service providers, correct? The new 30-day rule has to be complied with.
The 30-day rule through your chair has been there, but the monitoring of the payments is the one that will make you to achieve. And I think in the institution before we were not making that up, and we are now getting that correct.
Okay, well, that's not the experience of my team. They have not been paid, but I suppose there's still room for improvement. I think reasons why they're being punished here. But okay, so now when it came to the backlog project, what was the standard that was, in other words, what would happen if I'm an investigator, I have new cases that are coming in, but I also have to manage the backlog. So could that have also contributed to the fact that people might have felt that there are deadlines to do with the backlog and also deadlines to do with the current pipeline and maybe feeling overwhelmed?
Without having analyzed that part, investigators, they've got different complaints that ranges in terms of different times. So if you have backlog cases, you also still have new cases. So I'm not aware of a situation where an investigator is only having backlog cases. So you'll have a mixture of backlog and a mixture of new cases. So your timelines will differ depending on the number of cases and the age that you have. And I think you will be correct to assess that that could have also caused the problem in terms of deadline.
Yes. You've also testified in terms of the, well, just to close off the issue of deadlines, whether they had to do with backlogs or current work. Your view is that this was a necessary intervention and it improved the lot of the public that was complaining, because after all, you were the public protector and not the staff protector. Were you, or rather, was all this that we've discussed, did it translate into faster service delivery, I think, which was the word that you used?
Yeah, my comment, advocate through you, Chairperson, is the monitoring of the backlog projects also assisted in terms of getting cases resolved. And it also improved the way in which our cases are mixed in terms of what we have. Because I may not remember it correctly, but the public protector was indicating that before I leave, I would want to see cases that maybe only begin, I don't know whether it's 2019 or 2020, that will still be here. So when I leave, at least have those cases. But you can't have cases that dates back to 2017 or so. I think that was the target. And I think people know in terms of what she has been saying. And yes, for that to happen, the monitoring had to happen the way it happened. Whether good or bad, I can't comment on that one, but it happened in that way.
Yes, no, she will testify to that, that the most cruel thing you can do is to leave a mess for your successor. So she's determined that that should not happen. Yeah. Now, and you say that...
On that point, Advocate Mpofu, on that point of the mess,
yes.
I'm going to ask that we pause there and we take a lunch break and we'll resume at 2. Thank you.
Thank you, Chairperson.
Meeting adjourned until 2. Thank you.
Recording stopped.